Happy New Year, everybody. Happy New Year. Gosh, it feels
Hello.
like New Year was like a year ago already because so much has happened in the past week because everyone wants everything done in the first year of the new year. I'm sure that's happening with you over in management and the board members as well. Everyone hear me okay? Thumbs up. Yep, that's good.
Yes.
And so it's January 2023. The calendars are available. The dog of the day calendars are available for 2023. So many of you, if you are existing clients, you should have gotten them in the mail already, which is great. If you have not gotten them, please email over, and if you want one, we will send them to you. So the 2023 dog of the day calendars are available and have started going out last week. Today's dog of the day is Teddy. Is Teddy out there, Eileen?
Yep.
Teddy is a picture of Teddy under Terry Vigiano's desk. Terry Vigiano is a longtime manager at First Service Residential. Terry has many, many years of management experience, and it looks like her dog is quite comfortable under the desk at work as well. So thanks, Terry, sending that in. That's great. Nice to see you. Nice to see Teddy. Very mellow looking dog. So let's go into the stupid announcements again. I'm sorry. These webinars are for educational purposes only. That's not legal advice. They don't form an attorney-client relationship, and they won't be confidential, right? No information will be kept confidential. So if you want to get an attorney, you have to go out and sign a fee agreement with the attorney, and he or she will be happy to bill you like crazy. No, just kidding. Try not to, right? So anyway, we're going to talk today about rental units, which is vexatious, right? With respect to many associations, dealing with rental units is very challenging, and many boards and managers struggle with this. So the unit owner is responsible is the first bullet point. The unit owner is responsible. This gets lost in many associations because both the board and managers find themselves managing the tenants for the absentee owners, right? And that is a beautiful thing for the investor owner, right? Because they're not paying management fees, and the manager or the board members are the ones shouldering all the hassle and all the headaches that go along with many tenants. Not all tenants, some tenants are wonderful, but many times tenants just don't care, and oftentimes the absentee landlords don't care either. Many times in the recent past, the landlords are actually in different countries. They may be over in China, they may be over in India, they may be over in Europe somewhere, and they are just not taking care of business with respect to their investment units. So the unit is responsible. The unit owner should be held responsible. Violation letters, etc., should go to the unit owner. Okay, not the tenant, to the unit owner. Fines, etc., should be posted to the unit owner's account. You're not sending fines to the tenants. ADR, so ADR is required in landlord-tenant issues association versus the unit owner. Again, association versus the unit owner, so you offer ADR. You can fine, you can suspend membership rights, even if it's a tenant-occupied unit. But again, you'd have to offer ADR to do that. A common question is, hey, can the association charge administrative fees for dealing with absentee landlords and tenant-occupied units? The answer to that is it can be complicated because the law, the cases in the area basically say the association cannot use administrative fees as a profit center. So the only thing that the association can do with respect to rental units and administrative fees is pass on any costs that it incurs in addition to other units, owner-occupied units. So for example, if the management company or the management staff charges an extra fee for doing certain work, collecting leases, monitoring leases, handling, helping with move-ins, move-outs, etc., you can do a pass-through, but the association can't use it as a profit center. All right, so there are many associations out there who say, Fran, you know, we'd like to charge $500 a year for the lease. And I say, for what? And they say, for nothing. We want to get $500 a year for the lease. And that just isn't right. And that is contrary to the standing law in that area. Move-in, move-out fees, same thing. Move-in, move-out fees and things like deposits are only, and there's case law on this. I think it's the Halpern case. I don't have it in front of me, but the things like deposits can only apply if deposits also apply to owner-occupied units. Move-in, move-out fees, same thing. So what about the move-in, move-out fee? Many buildings on the Gold Coast ignore what we talk about, and they charge move-in, move-out fees anyway. For those of you who are Gold Coast people, I don't see too many of you out there tonight in our high-rise buildings. But move-in, move-out fees are a problem if they are used as a profit center. They should not be. So what can you do with respect to move-in, move-out fee? You can do a pass-through charge, right? If there is an actual administrative charge, you can do a damage assessment to the unit owner. Again, if somebody is moving dressers in and out of the unit, damaging wallpaper, etc. Again, it's not the charge to the tenant, it's a charge to the unit owner, right? So we all know, for those of you, especially with high-rise buildings, that people moving in and out regularly damage things, regularly mess up the association's staffing, right? Because they want to use the freight elevator. They're supposed to provide certain notices to have the freight elevator. They don't do that. And then there's a staffing issue. So if there are charges, those additional charges can be passed through. You just can't collect a chunk of money and intend to keep it for nothing. And what about restricting the number of rental units? It's permissible. We've talked about this before. It's permissible. You can cap the number of units. You can cap the percentage of units if you like. You can also add a seasoning provision, which a seasoning provision basically says that a unit once purchased must be owner occupied for a certain minimum amount of time prior to it being rented. Seasoning provisions really are effective in controlling the number of rental units that come about within a community, right? So this is especially applicable to real estate downturns. So we don't know what's going to happen in 2023, but if we have a downturn in the economy and the value of homes go down, you may well see more real estate speculation in community associations as investor owners try to glom up units during a downturn. This happened like crazy in the 2008, 2009, 2010 time, right? When real estate prices were awful and real estate speculators were coming in all over the state and buying units and trying to turn them into rentals. So the seasoning provision can really slow that or prevent it. Capping the number of units or the percentage of units can also put a limit on that. But we find the seasoning provision is much more effective.
Hey, Fran,
yeah, go ahead. As Mike, yeah, go ahead.
Just a quick comment on that. So if your community is considering obtaining FHA approval for the entire condo or homeowner association, just know that a seasoning provision will prevent you from getting that FHA approval. So they change their rules kind of fluidly. This is the FHA. And the last one was a few years back, and they said if you have that in your bylaws or your master deed or your declaration, or if that's a policy that you have, you will not be eligible for FHA approval. So just kind of balance those two interests when you're talking about it next time.
Yep. And Mike and I were talking before we flipped the switch to bring everyone on. We recently litigated two cases where investor owners came in and they challenged the rental restrictions, and they were successfully upheld by the court after a considerable amount of litigation, and the association wound up getting its attorney fees awarded. So it was a very nice win, and it also was very helpful that the association got reimbursed its attorney fees.
And in that particular case, I believe it was a 3-year seasoning provision that somebody had challenged, and the court upheld it and provided all of the association's attorney's fees, which was great.
So it worked out. That worked out very well. We don't like to see the associations have to litigate them, but it's an association that was, I'll say, it was in bad shape when we were brought in there, and when we cleaned up collections and we cleaned up rentals, the association is night and day today. And I could also give credit to the management staff there that has done a great job. But it really is night and day in the community, cleaning up the rentals and cleaning up the arrearages and making the unit owners responsible for their tenants has really helped the quality of life there and has really helped the curb appeal. Everyone talks about curb appeal. It has really helped the curb appeal. The caveat with the rentals and the capping, the rental restrictions, capping and seasoning, et cetera, is you have to be careful if you're going to have a hardship provision in there. So many associations want to include hardship provisions in their rental restrictions. And the reason they want to do that is to be human, to be equitable, to be nice. What happens if someone dies? Should we let them rent it, right? Someone moves in and the unit is underwater because the market has turned down. Can we let them rent it? I don't know. You could do that if you want, but you could put that in your amendment. Divorce, same thing. Should divorce be a hardship? Couple moves in, the market goes down for real estate values. The couple decides to get divorced. They cannot afford to sell the unit because the unit's underwater with a mortgage without bringing cash to the table, but they're going their separate ways. Should they be permitted to, in the case of divorce, rent the unit? Same thing with a job transfer or a military assignment. What do? Do you make them exceptions to the rental restrictions? Somebody's assigned overseas. How do you deal with that? Most associations do contain some type of hardship provision, whether it's death, divorce, job training, military, etc., especially in a down market. The caveat there is the next bullet point. You have to be very careful of illegal discrimination, right? Because once you get into making a judgment call on who counts for a hardship, you have to make sure you don't deny a hardship, right? If it's for the right reason, but the denial is based on the wrong reason. And everyone knows, you've seen me say these words many, many times, you can't make housing decisions based on race, color, creed, national origin, sexual orientation, trans status, et cetera, on and on. There's a whole litany of them. I could probably write a book on them, but you just have to be very, very careful when you are granting or denying exceptions to restrictions, because the exceptions can involve an illegal discrimination case, and you have to speak to your attorney if you're going to go down that road. Okay. Mortgage lending impact, Mike already mentioned that. The seasoning can knock you out of HUD and FHA approval, although that is an evolving issue. It seems to change every year. There have been some instances where FHA is allowing certain things if the association is not entirely FHA certified, but people must show that only 10% of the mortgages within the community or less are FHA approved, whereas in a certified community, you can have up to 50% FHA approved lending. So there are lots of caveats to that. What Mike and I have talked about in the past, which you don't see as much anymore, used to be able to get spot approval for certain lending for just one-off deals, if you will, but we don't see that anymore. But if you have an FHA financing issue in your community, speak to us, speak to your attorney regarding whether or not there is a way around that. Association-owned units. So many associations, I think many of you out there might have either now or have in the past owned units. The association itself owned units. So when you own a unit, even if it's subject to a senior mortgage, you have to make sure that you treat the unit as the association's unit. So if it's vacant, you got to make darn sure it's winterized. You got to make sure it's secured, make sure it's preserved, etc. If it is habitable, you want to get it rented, keep it rented for as long as possible, or at least until the mortgage company comes in. We have one community, Leisure Village East, who has had a unit for years and years and years, and just keeps running it, and everything's fine. But keep in mind that the association must add those units, those rental units, to its insurance policies, right? So there's a new law that came out, I guess, in November, which becomes effective in the beginning of February, that basically says that anyone who has a rental unit must insure for a minimum of $500,000 for liability insurance, damage to property or people. And the association, if it owns units, can secure that coverage by adding it to its existing policies. And most associations, that's what they do. The association's own insurance carrier will just add it to an existing policy. They don't have to go out and get a freestanding policy. The little wrinkle on that is, unlike the past, you now have to file the certificate of insurance with the municipality. So for those of you who have ever rented or had investor units yourself, you know that you have to file the certificate of registration with the municipality that you're renting the unit. Now you have to do two things. You have to file the certificate of registration, and you have to file your insurance certificate proving that you've complied with the new law. Okay, there is a fining provision in that new law that says if you don't carry the proper insurance, that the municipality can fine the property owner, the unit owner, if they don't provide proof of insurance. That is different from the registration of the unit with the municipality, because the way they enforce the registration requirement with the municipality is you are not allowed to sue to evict a tenant if your unit is not properly registered. So you're stuck if it's not properly registered. I know some of you, I think, have residential investor units out there. You don't want to get stuck on that. So that's mortgage lending, association-owned units, insurance. We talked about bad tenant behavior, right? Everyone, you hear about tenants when they behave badly. You may have heard me speak of a case I had in South Brunswick a couple of years ago, where we had the tenants, for whatever reason, there were stacked apartment units, condo units, that I was the mediator in the case. And for whatever reason, the tenants would, garbage, like old school garbage, like food stuff, not trash, but garbage, food stuff. I don't know if they were environmental people or what, but they would throw their food waste out the kitchen window, right? Spaghetti, etc., in the shrubs. Like, that's crazy, right? That's insane. But that's a problem. We can't do that. Marijuana, right? Marijuana, smoking in the common hallway, in the common stairwell. It's like a Cheech and Chong movie on the landing, right? You don't need that, right? So that's bad behavior. So we can't have Cheech and Chong in the building. There are certain issues with that. Mike and I were talking again before we got on that the law with respect to legalized marijuana, Mike, you can chime in, apparently allows associations to ban marijuana smoking within the unit if 51% of the units within the community vote to ban it in the unit, right? So again, this is really a hot topic for our high-rise clients up in Jersey City, Hoboken, etc., because it's really, really, really difficult to contain cigarette smoke, and it's really, really, really difficult to contain pot smoke, right? It's like, it just kind of hits you in the face. It's like that weird, sweet smell. You can almost taste it walking down the hallway. Feels like it sticks to your face, right? So that's an issue. So that's some of the bad tenant behavior. The other bad tenant behavior is all kinds of stuff, right? We know about parking. We know about people driving across the common areas. We know about the parties, the late night 2 a.m. rocking the music, and the landlord is just not taking care of business. What can you do? You should fine the unit owner, right? You should deny privileges. You should send them the ADR. And the ultimate thing is, if you have to, most association governing documents have a power of attorney that if the unit owner fails to act, the association can go in and initiate a landlord-tenant action. The only caveat to that is landlord-tenant court in New Jersey, very, very high bar to get someone kicked out. Super high bar to get someone kicked out. So you really have to make a record, like a phone book, right? We had the police out here on July 1st. We had the police out here on July 15th. We had the police out here on August 15th. We had the police out here in September, October, November, December, blah, blah, blah. This is a real problem unit. The police themselves made a drug bust at the unit. The police themselves found, people in a fist fight on the front yard, etc. Everyone, I think, has some familiarity with these types of units. And especially when you see people who are absentee owners that are not around. They're either not in the state of New Jersey or they are out of the country. They will oftentimes, even if they communicate with you, they'll say, hey, I'm out of the country. I can't do anything. Well, the answer to that is you sure can do something. Hire an attorney, get the tenant kicked out or straighten out the tenant. The rest of the unit owners and residents should not have to live in hell, and the manager should not have to live in hell managing the owner's tenants because the tenants are wacky, or because the unit owner likes traveling to Europe or India or China, wherever they happen to be traveling. God bless them. But they can't just shirk their responsibility. So ultimately, we the lawyers may have to file a complaint, a landlord-tenant complaint, on behalf of the unit owner, step into the unit owner's shoes and charge the legal fees back to the unit owner for dealing with the bad tenant. Okay, Mike, you want to jump on anything there?
Yeah, along those same lines, just this past Wednesday, I had a manager reach out to us for us to now finally get involved. They sent over a tenant who had 58 pages of police reports for noise violations, fighting at the unit. And I could not imagine living next door to that person. So to your point, if you do not have that attorney in fact provision, which allows the association to step into the shoes of the landlord and actually evict if the landlord doesn't do that, it's something you would want to add to your governing documents, into your bylaws. We would typically add something like that using that rejection ballot method to amend, where the board passes the amendment, gets mailed out to everybody. They have 30 days to then reject it. And if less than 10% reject the amendment, it becomes effective. It's relatively easy to pass, and it goes into your basket of good things when you're dealing with these unruly tenants that have 58 pages of police reports.
Yep. So it's all about building the record when you have the problem tenant. So the first question is, in associations that do not allow short-term rentals, and you have a unit owner who states that it is their relative, and we know that is not true, what can be done? So the problem with all law, right, is you have to prove your case. So that's a really good question there, Muriel. You do have to prove your case. And we would need to know, how do you know it's not a relative? And we have to prove it. So for example, we had a case probably 2-3 years ago where a gentleman had another gentleman living with him, and he was saying the same thing. Hey, this is not my partner, and it's not a domestic situation. It's not my husband, etc. He's just one of my relatives who's living with him. So we found out it wasn't his relative. But what we did find out, in addition, by going through the internet and looking at VRBO sites and other short-term rental sites, was that this guy was renting out his spare bedroom. And almost every set of condo documents say that if you rent out the unit, you must rent out the whole unit. You can't turn your apartment style unit into a rooming house, right? So you rent a bedroom to Bob, you rent a bedroom to Kenny, and you stay in the third bedroom. No, right? That's not the way it's supposed to happen, because that's the ultimate transient situation. In that case, the guy fought for a little bit, but we were able to get the third party out. And eventually he turned the unit into a full-time rental, which was okay. He started doing it legitimately, and that's fine. But as far as the case about, the person claims it's a relative, you have to be able to prove the case, which can be difficult at times. Mike, you want to take the next one?
Well, just another comment on that. So a lot of times we'll put into an amendment a seasoning provision that if it's owned by an LLC, that a member of the LLC or corporation must actually personally reside there for X amount of years before being eligible to rent it out. We did that at a community in Ocean County, and believe it or not, the landlord who just bought the property had not resided in there and bought it in an LLC, started renting it. We found out, we sent a violation notice. He then reaches out to the tenant and says, hey, tenant, how about this? I'm going to add you to the company to make you a member of the LLC so that you can continue to live there. And that's what he did, which was completely insane, but he worked his way around the seasoning provision. So I guess my point is, with both relatives, with LLCs, sometimes you come across some tricky situations, and you have to look at them on an individual basis.
Right. Similar to that, we've had cases where, especially like in Somerset County, where there's a lot of corporate headquarters and so forth, where a corporation will go in, enter into a lease, a multi-year lease with a unit owner, and then they will be running middle-level executives in and out of the townhouse condo unit. And they'll say, well, Fran, we have a multi-year lease. This is not a short-term rental. And we've argued, so far so good, we've won the cases, saying, no. It's not just about the term of the lease. You can't turn it into a transiently occupied, extended stay America because you have a 3-year lease and you're just running executives in here who happen to be here for a week at a time or 2 weeks at a time, what have you. No. So that, like Mike said, many of the landlords can be quite clever in terms of trying to get around your restrictions and defeating the restrictions. But so far we've been fairly successful in stopping that. I missed one. It flipped up on me. When the homeowner of a rental unit puts in an insurance claim, is there a legally binding timeline in which the HO insurance must answer the homeowner's claim, So a homeowner of a rental unit puts in an insurance claim. So the association is typically the one who submits an insurance claim if the association is the primary insured, right? If the unit owner, who would be the investor owner, puts in an insurance claim, they have to respond to the unit owner. But there is no time frame, as far as I know, unless it's in the association's policy, within which the association's carrier must respond. But so that would be an issue for the association as well. If an association carrier is not responding, we would get involved and make sure the carrier does respond. And if they don't respond in a timely fashion, we file what's called the declaratory judgment action, where the court basically makes the association's carrier either provide coverage or give a denial based on good faith policy provisions. Go ahead, Mike.
Yeah, we skipped a few.
Oh, yeah, okay.
So I'll start with the first one. It says, this pertains to the violation letters. We send them both to the owner and the renter. Is that okay? So typically what we'll do is we'll direct the letter to the owner and copy the tenant so that they know about the violation. A lot of times in the lease itself, it will say that the landlord has a right to assess back to the tenant as additional rent any fines. So it ends up with a tenant sometimes as well. The next question says, what is a reasonable time for a seasoning provision? I can take that. Most of the ones that we put together are between 1 and 3 years. I don't think I've ever seen one longer than that. Fran, I don't know if you have.
Yeah, most are 2 years. Probably the majority are 2 years. The kind of classic case that comes out of Cape May County on it was a court upheld a no rental provision, no rentals. So we don't encourage our boards to go down that road because we think it's probably going to spark litigation. But as Mike said, it's usually between 1 and 3 years. Go ahead, Mike. Can a board vote?
Yeah, so can a board vote on restricting leases, or does it need to be in the governing documents? So the restrictions, something like seasoning provisions, capping the number of rentals, those are big rights that you have when you buy a piece of real estate. Taking away something from that bundle of rights would require an amendment to your governing documents. Something like passing through a cost, like a management fee to deal with tenants, those perhaps could be included in resolutions requiring that the landlord provide a copy of the lease, for example, to the association, could be in a resolution. But if you're going to put amendments in there anyway, you're probably best off just putting it all together in one, all of your rental restrictions and requirements together in one amendment.
Right. Okay. So there's one from Keith. It was similar to the earlier one. Keith Seiler, what's up, Keith? I haven't seen you in a while. Can't see you on my screen either, but you're probably on the other screen. In associations, do not allow short-term rentals, and you have a unit owner who states it is their relative, and we know that is not true. What can be done? So as I said before, you got to prove your case. I think I was addressing Muriel's question earlier. You got to prove your case. So you got information that shows that they're not relatives and they're not just living there for free. My nephew's living there, my niece is living there, what have you. And you can do that by suing them if you have a good faith belief that they are not relatives. And then once you get discovery, you get them in paper discovery, and then you also get them sit down in a deposition and ask them the questions. The problem with that is money, right? So you have to decide how valuable it is for the association to go down that road to deal with the one knucklehead, right? If you're spending thousands of dollars in attorney fees, you have to be sensitive to that. Go ahead, Mike.
Sure. Marge asked if we could email a copy of the new law to her pertaining to, what was the one, Fran? You had mentioned it earlier.
Oh, the insurance? Yeah, the insurance. Yeah, the insurance mandate. Yeah, we'll send you a copy of the new statute. Yep.
Okay.
Yep. I think it's, like I said, it goes into effect, I think, February 3rd. Most associations that we work with automatically, we talk to them, they automatically add the unit to their insurance. The questions are jumping around a little bit. It's kind of funny the way they're coming up. Is the seasoning percent or number of rental units a statute, or does it have to be in the governing documents? So it has to be in the governing documents, so that if it's going to be a percentage or a number of units, it would have to be in the governing documents, most preferably in the master deed or declaration. Some associations roll the dice and put it in the bylaws. I think there's a greater risk that the the bylaw amendment with respect to this would be defeated if it was challenged in court, because you're dealing with limiting property rights, which are usually governed by the declaration or the master deed. So we much prefer to see the amendments go in the declaration or the master deed because we think they're much more enforceable.
Ann asks, what percentage of owners can vote down a new board amendment? So it's 10%. It's the rejection ballot. Board passes it at an open meeting, gets mailed out to the owners along with a rejection ballot. And if more than 10% of the owners vote to reject the amendment, it would not become enforceable. It wouldn't pass.
Okay. These are kind of out of order because I'm getting some ones from a different, I guess, email. What do banks consider an acceptable number of investor-owned units beyond which it affects the ability of a buyer to get a mortgage? Does it increase the mortgage lending rate? So certainly, I wish I had a straight answer. It depends on the various lending programs. So, and this has changed in the recent years. So FHA, for example, for a long, long time had like a 35% cap on investor-owned units before I would stop lending. I think after 2008, 9, 10, that was revised upward to 50%.
Yeah, it's 51%. Yep.
Yeah, so it was up to 51%. That though may be very different if you're looking at other types of lenders. So I think the real answer to that is it depends on the lenders. FHA certainly does have a cap. As if Mike, you're more familiar with it more recently, it's probably 50%.
Yep.
But go ahead.
I was just going to say, so there, when it comes to lending, it's 51%. So you don't want to go, not more than a majority. But once you get over like the 30% threshold or so, I've been told from the insurance brokers in the industry that's going to start to affect your premiums. So you try not to get over the 25 or so % if possible.
Right. Mike, did you address Ann's question about what percentage of owners?
Yep.
And reject. Okay. Is there any legal reason why a property manager would refuse to allow recording of an open Zoom meeting of the board? I asked for a recording of an open board meeting and I was unable to attend. The property manager advised that multiple attorneys advised that it is not legal or advisable to record open meetings so that homeowners unable to attend meetings can hear what occurred on the call. So there's nothing that I know of that actually mandates the recording of just a regular open meeting of the board. For those of you who know me, I am very much an advocate of transparency and a proponent of giving an opportunity to as many residents as possible to watch meetings or listen to meetings live in person or on Zoom if possible. And it is, as you know, Zoom is kind of a new world order for community associations and condominium associations. I can tell you, in terms of lifestyle, it has made my wife so much happier that I'm not driving back and forth from Atlantic City at 11 o'clock at night or driving back and forth from Sussex County at 11 o'clock at night. And I can just jump in and out of board meetings from my desk. It has also made many of my clients really, really happy because they're not getting me billing them for sitting in a meeting for 3 hours and getting charged for that. Sitting in a meeting for 3 hours when I can just jump in on a Zoom and deal with whatever the narrow issue is, and then leave, right? Because all of you know it's very hard in a live meeting when a lawyer gets there to come back pre-COVID to address a particular issue. Okay, we want to talk about the new parking lot scheme, right? The problem with this is, and I'm not patting myself on the back, often when you get a lawyer in a live association meeting, that lawyer becomes a lightning rod, if you will, for a stump the lawyer campaign, right? You know what? I know, Fran, you're just here for the parking lot issue, but I need to know if my next door neighbor put cigarette butts out on the lawn, like, can I sue them for that? You're like, no, I'm here about parking. Leave me alone, right? I don't care about your cigarette butts right now. But you wind up getting sucked into the lawyer sitting there playing stump the lawyer at an open meeting, and it winds up costing everybody a lot of money. So Zoom has been awesome. And the Zoom meetings, I think, have been great. A number of my associations, I think Four Seasons at Lakewood being one of them, actually way prior to COVID, had a media club that recorded the live open board meetings and replayed them on their closed circuit television in a loop, right? So that people who missed the meeting could see the meeting, and it was fantastic, and I think it still is. So I'm a proponent of that. The lawyers who say, let's not do that, do have a good reason for saying that. Do having a good reason for saying that. And here's the reason. People can say and do really stupid things in meetings, right? And when they do that, and you preserve a Zoom meeting, a video recording, etc., or even an audio recording, that is discoverable, right? So somebody says something really stupid, and it was just a mistake, or it's, you know, a brain fart, if you will, and that is preserved for forever. And if a litigation happens, it's discoverable. So you get the subpoena that says, please provide me with all video recordings, audio recordings, any other documents that reflect what went on at the meeting. And whereas for the most part, pre-COVID, you did not have a contemporaneous sound recording or video recording, you would just have the minutes, right? So the minutes of the October 15th meeting would just be very plain vanilla, and then you'd have them there. Even in the communities where you had audio recordings back in the day, the audio recordings would be subject generally to a destruction policy that said once the meeting minutes had been transcribed or approved by the board at the next monthly meeting, the audio recording would be destroyed. Not in response to a litigation or anything, it was just the practice that the tapes were there merely to help the board secretary do the minutes properly and accurately. So in my view, it's up to the board what they want to do. It's a policy decision of the board. I am generally a proponent of openness and allowing a process where people can attend Zoom meeting or people can view a recording after the fact. Notwithstanding that, that is the more hazardous route. Because this will shock you. Even I have said stupid things in open meetings. So it's you have to be careful, because the things just don't go away, and they are subject to discovery. And I can tell you there are very many board members who would say, Fran McGovern, you are out of your mind. The last thing on the earth we'd ever want to do is have live Zoom meetings and then have the recording of the Zoom meeting available to our members, right? You're putting us too much at risk. And when I talk to boards about this, I explain the risks and the benefits of both approaches to it, but there are certainly risks because it is discoverable.
Hey, Fran, just two quick comments on that. So the DCA regulations that came out in 2020, they actually specify in there that if you record a meeting, it must be made available to the members. So if we record it and destroy it, great, but as long as it exists, it must be made available. And the other kind of comment on the side is, whenever I'm on a Zoom meeting, and I suspect everybody should do the same thing, just assume you're being recorded. It's everybody's carrying around in their pocket a recording device, audio recording device, right? Even if you can't see it on the screen, it's very possible somebody's just recording it from their Zoom.
Right. That's a very good point. And I'll have to check that. I'll have to check that Radburn reg too, right? Because there was, I think, an additional provision with respect to the recording of the election meeting, right? There was something about that if it was virtual, it had to be preserved for a certain amount of time. So I'll have to check that. But to follow up on Mike's comment, even pre-COVID, it was virtually impossible to stop at least an audio recording of the meeting, right? So the boards would say there are no recordings allowed, which I disagree with, but you would be sitting in the meeting and everyone would be like, yeah, I'm not recording anything. And then you would see a little red dot, this tiny red dot in the lady in the front row's purse, right? You're like, I wonder what that is. And you know darn well she was recording the meeting, right? But what are you going to do? You're not going to stop and frisk her, right? So what can you do? You have to assume you're being recorded in any case. Go ahead, Mike.
All right. The next one here says, can a landlord owner legally ask a tenant to vacate at the end of the lease so the owner's child or parent can occupy the property? Basically, it's a relative not on the title, and are they considered an owner occupant? So just so everybody knows, what happens in New Jersey is when you have a term lease and it comes to an end, you can't just remove the tenant. The tenant has a right to stay in that property for the rest of their life. As long as they pay reasonable rent, they become now a month-to-month tenant, okay? The only way to remove that person, unless they voluntarily agree to move out, is if the owner of that property wants to move in, then as the owner, you can set aside the lease, any term lease or a month-to-month lease, upon 60 days notice to the tenant. And if they don't move out, you can file an eviction complaint and get them out. So this question is, can the landlord get the tenant out so that the landlord's child can occupy the property or parent? I don't know the answer for sure. I suspect the answer is no, because the last time I looked at that statute, it was pretty clear in that it said it's an owner occupant that is allowed to terminate a lease or remove a month-to-month tenant. So I don't
Yeah,
think.
well, I haven't looked at that statute in a while either, but the basic question is, does a family member fall within the definition of an owner occupant? So, what we could check that, who was that? That was Karen, right?
Yep.
We could check that, Karen, and get back to you on that. We just check the statute. I think my gut is the answer is no, but we can check. Phil Lampe, hey Phil, I saw you out there somewhere. There you go. Hey Phil. He says, what is the source of this insurance regulation? I have the statute here. It was passed, it looks like August 5th, 2022, and then it was adopted in November. But we're going to send out we'll send you a copy of the actual statute, Phil. Do I have the Senate number 1368? If you want to go on the legislative website, it's Senate number 1368. And it was effective as of November. So that's the insurance one. What is the source of the changes? Would your proposed amendments regarding rentals have a grandfather provision? So typically they do, right? Typically, if you get into a situation where there are existing rentals, there is a grandfathering provision there. I can tell you that these things were hotly contested in the 2008, 9, 10 time. And close your ears, Marge, because I know you're a realtor. The realtors were the ones standing in the back of the room that say, I live here. I am a realtor, and I'm going to sue you if you try to prevent me from buying more units here. And knock on wood, thank God, none of them did, because that would have been really annoying and expensive. But they generally do have grandfathering provisions for those existing rental units. Go ahead, Mike.
Oh, yeah, sir. Can associations charge a unit owner a renter deposit along with a move-in fee, while owners only are charged the move-in fee? I do not believe we can distinguish between tenants and owners. I don't think that would be enforceable. So
yeah, no, it's not going to work. It's not going to work, Keith. The problem, Keith, is that many buildings get away with it. Many buildings get away with it. Eventually, someone will step up and sue. Go ahead, Mike.
The next one says, do the associations have to make copies of the recorded meetings, and how long do they have to maintain the recordings? Meeting minutes, off the top of my head, I believe, and I suspect the recordings fall into the same thing. I believe we have to maintain the meeting minutes for 2 years after the meetings. That's from the DCA regulations. I have not come across anything mandating that any meeting needs to be recorded, just that we have to maintain meeting minutes.
Okay. So what you should do if you're running into this is have the association put together a document retention, production, and destruction policy. So obviously it has to, as Mike said, you have to be in line with the DCA regulations. So that's the retention part. The production part is really important, especially if you have a wacko factor in your community, which most communities do. You have people that say, I want you to produce all of the association's governing documents, books and records, blah, 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 since 1895 forward, right? And you're like, what? That doesn't make sense. And that's going to cost $1 zillion. And the manager is going to hate me. So the production, because you can pass on reasonable charges for production. So document retention, production, and destruction. which says not only you're going to retain it for a certain amount of time, you're going to destroy it after a certain amount of time, and you're going to destroy it in a certain way. So for example, McGovern Legal has a contract, I forget the name of the vendor, but the vendor comes in, I think it's once a month, Eileen, you can tell me different. Yep. And he goes through all of our paper documents, which we keep in separate bins, marked separately, and takes them and puts them in the shredding truck. You know, so that, as you know, we do a lot of collection work here. So we don't have people's social security numbers, asset information, all that other stuff floating around in a dumpster where someone could dumpster dive and steal someone's identity. So it's document retention, production, and destruction as to you know, those three factors. So that can be very helpful. And like I said, it can be very helpful if you have a member there who's more or less just harassing the board of management with, you know, I want to see every contract, I want to see everything. Well, you may be able to arrange that, but it's going to cost somebody something. So what else do we have? Oh, hey, Keith, thanks. You do have the team on. Thank you so much. Let's see. Does anybody have anything else? Mike, you have anything else?
I don't see anything else here, Fran, no.
So thanks so much. It's a happy new year to everybody. And please, I get these emails sometimes that say, Fran, would it be okay if I sent this link out to everyone on my board and have them attend? The more, the merrier. You know, number one, I like this. Number two, I get more ideas for stuff to do the following month. And number three, it's a good marketing source, and we've gotten a number of new clients through it. So I really appreciate you attending, and have a great month, and we'll see you soon. Take care. Thanks for attending.